The Honorables, the presiding judge and judges of the Court of Appeals of the State of North Carolina. Oh yes, oh yes, oh yes. The Court of Appeals is now in session. God save the state and this honorable court.
Thank you, Mr. Soar, and good morning, everyone, and welcome to the virtual Court of Appeals by WebEx. We have two cases for argument today, and this is our first one, which is State of North Carolina versus Taylor Garrett. Panel for our case this morning is me, Judge Donna Stroud. Also, we have Judge Hunter Murphy. Judge Murphy, if you say hello, just make sure your mic's working.
Good morning.
Okay. And Judge Allegra Collins.
Good morning.
Okay, very good. And okay, and so the state is the appellant in this case. So we will begin with Ms. Callahan's argument.
Good morning, Your Honors. May it please the court, my name is Kimberly Callahan. I'm an Assistant Attorney General for the Department of Justice, and I represent the state in its appeal. This morning, I would like to reserve 5 minutes of my time for rebuttal. The trial court, as a judiciary, has a duty to apply the law as it is written, and it failed to execute that duty in this case. By statute, the Superior Court had exclusive jurisdiction over the charged offenses, and a trial should have proceeded against defendant for felony breaking or entering and larceny. Instead, the trial court allowed the defendant to escape any accountability for his alleged criminal conduct by improperly dismissing the charges against him because by law he was required to be prosecuted as an adult because he had attained the age of 16 years old. The trial court erroneously concluded that this constituted a flagrant violation of his constitutional rights and irreparably prejudiced his case. This ruling is not supported by any of the authority that was submitted to or relied upon by the trial court and is directly contrary to the law as established by the North Carolina general statutes that were effective at the time of the offense. Defendant is essentially asking this court to be the first to hold that there is some inherent or fundamental right to access to the juvenile justice system. No other court, state or federal, has ever held that there is such a right simply because one does not exist. Trial court's order in this case should be reversed and the charges should be reinstated against the defendant so the state can proceed to trial. It is universally accepted that access to the juvenile system is purely a matter of procedure to be determined by the General Assembly. This is a power which was solely given to our legislative branch by our state constitution. Since 1919, over 100 years ago, North Carolina's age of exclusion from the juvenile justice system has been 16 years old. Defendant here is no different.
I'm going to raise my hand. So at the time that these crimes were allegedly committed, can you hear me? Okay.
It's a little bit difficult, but I'm trying my best.
I'm going to shout, okay?
Yes,
all right.
Yes, you're on.
All right. So at the time that these crimes were allegedly committed, could the state have filed a juvenile petition against the defendant statutorily?
No, Your Honor, because in 2015, Section 7B 1604A specifically excluded juvenile defenders or defendants who are 16 years old. So by statute, he was excluded from the juvenile system, and the Superior Court had exclusive jurisdiction over the charged offenses.
Okay, so if they could not have filed a juvenile petition, and if, according to the defendant's argument, they could not have indicted this person, does that mean that there's essentially a 2-year window during which a group of individuals would be held harmless, basically harmless for anything that's been done?
Well, according to defendant's argument, that is correct. According to our general statute, the Superior Court had jurisdiction over the charges that were filed, and an indictment was proper. That was the due process that was necessary for the defendant to have notice in a hearing. The notice is the indictment that is filed. The hearing is the trial that should have proceeded in this case.
But could you, but you couldn't file a juvenile petition, and if then an indictment wasn't proper under defendant's argument, then there's a hole there. Is that correct?
The defendant's argument is correct. Yes, that's true, Your Honor. But the state's position is that the indictment was proper here because he was specifically excluded from the juvenile code, and so the Superior Court would have had jurisdiction over anybody who is 16 or older and who had committed a felony in the state of North Carolina. So the indictment was actually.
Did the state now turn around and file a juvenile petition?
No, Your Honor, not based on the law that was written at the time of the offense, and that is what controls here. Yes, Your Honor.
Is there, in the juvenile proceedings, would a defendant or juvenile have any right to have a jury trial, or is it merely decided by a district court judge?
Would he have a right to have a trial in district court? Is that your question, Your Honor?
Would there be any right to have a jury in the juvenile proceedings? There's no provision for that in the statutes, correct?
No, Your Honor, that is correct.
One question, and this will put the cart a little bit before the horse, but assuming we agree with you as it goes through your brief, and we decide this is, subject to rational basis scrutiny, is the state limited to arguing for rational basis those purposes of sentencing set out in 15A 1340.12, or do we have more wide latitude in considering rational basis other than what the legislature has set out as the purposes of sentencing?
Well, I think before we get there, before you would even have to apply a rational basis test, you would have to find whether there was some liberty interest that was being deprived here, and there simply is not. There is no fundamental right, there is no inherent right to be tried as a juvenile. It's universally accepted that this is something that is determined by the legislature. And since 1919, 16-year-olds have been excluded from the juvenile justice system. It's just now recently, based on brand new legislation, that they would have a right to at least initially have their case originated in juvenile court. But even under raise the age legislation, there are still a number of juveniles who will be excluded from the juvenile justice system. And I think going back to your question, Your Honor, there is a rational basis to differentiate between juveniles who are older and who are younger in the justice system. And it has always been, since 1919, that this particular juvenile would have been excluded. It is just now based on this new legislation that had this applied to him, his charges would initially have been originated in juvenile court, but he still could have been excluded. Now, if raise the age had been applicable to him, there would have been, he would have been entitled to a transfer hearing where the judge would make that discretionary call whether or not to bind him over or not. But it's simply not. And the rule of law is that the statutes that are in effect at the time of the offense was committed govern this case. And those statutes say that he's excluded from the juvenile system and must be prosecuted as an adult.
If we're considering the rational basis standard, what arguments were made by the state below that this has a rational basis?
I think the state's position below was simply that there was no constitutional violation here at all. I'm not sure that the state got into that type of analysis. I'm not really sure that the defendant got into that type of analysis. It was more the transcript focuses on whether or not there was a constitutional violation to begin with. I'm not sure that this was actually discussed very thoroughly down below, Your Honor.
What is the rational basis that the state would like us to find if we decide this is subject to rational basis test?
Well, there's a rational basis. The legislature is free to include or exclude any person from the juvenile system that it deems necessary. It is always it's always differentiated between older and younger juveniles. This new legislation takes into account, its improvement, it's improving its statutory scheme, and the legislature has the discretion to do so. The raise the age was made so that, for the benefit of 16 and 17-year-olds. It saves money. There's any number of reasons why the legislature can determine that there should be a statutory change in its scheme. So, yes, Your Honor.
To follow up on that, did our General Assembly raise the age to cure any constitutional violation?
I'm sorry, can you say that one more time?
Yes. Did the General Assembly raise the age to cure some constitutional violation, or were there other reasons why it did so?
No, Your Honor, there has never been any case, there's not a single case in this country that says there's some constitutional violation because a 16-year-old was prosecuted as an adult. This was done for the benefits of juveniles to save the state money. There is no constitutional violation here, and I'm prepared to walk through each of the constitutional violations that the trial court found and to explain why these conclusions of law are erroneous in the order that the trial court addressed them, unless this court would have me focus on a specific issue.
If Ms. Callahan, I got to ask. So was this as an as-applied or facial constitutional violation, or did they make that?
As best as I could tell, it was maybe both. I'm not sure. There wasn't a differentiation between as applied or facial. If you read his motion, it seems to cabin its argument to juvenile offenders who fall in between who are charged in between the passing of this legislation and the effective date. So perhaps that could be categorized as facial. I'm not sure.
It doesn't really seem focused on the defendant in particular, other than, obviously the argument about immaturity and brain development and all those things would apply to any juvenile potentially of that age, although I guess there was a little bit of talk about when he was particularly immature. But it seems to be sort of more of a broad thing to basically anybody in that category.
Yes, Your Honor, that would be my understanding. There was not any evidence of his individual immaturity or anything that the trial court found. This was as applied to this particular juvenile. It was more of a broad statement that because this juvenile fell into a class of defendants where raise the age was not applicable to him, that it violated his constitutional rights. So if this ruling was upheld, I don't see any reason why this wouldn't apply to any other defendant who also fell in that class.
Do we have any case law under 15A 954A4 differentiating between a violation of a constitutional right and when a constitutional right is flagrantly violated? Is there any differentiation in our case law yet regarding that, the use of the word flagrant by the legislature?
Your Honor, not that I could find. Basically, the case law that I've been able to read up on just basically decides whether there was a constitutional violation in the first place. I'm not sure that there's any case law that differentiates between when it's, I don't know what you would call a regular constitutional violation or a flagrant constitutional violation. I think the difference here is not only do you have to find a violation of his constitutional rights, but he has to have been irreparably prejudiced also by this constitutional violation. And our case law says that under 15A 954, that this dismissal should be used sparingly. And so it should be the very rare case where there's one, a constitutional violation, and two, that also flagrantly violated, or irreparably prejudiced his defense. And the state's position in this case is that he can't make a showing under either of those prongs. And so the dismissal of the charges against him was erroneous as a matter of law.
And if we found that there was a flagrant violation, what would your argument be that he has not been irreparably prejudiced?
Well, this court has said to be irreparably prejudiced, it has to prejudice his defense. And he's not been put on trial for anything. So he can't show that this irreparably prejudiced his defense. There simply he hasn't put on a defense. There hasn't been a trial. There hasn't been any proceeding. I mean, this was pre-trial, a pre-trial dismissal of the charges against him. So,
but don't we have standards, for example, with a right to a speedy trial? You don't have to actually go through a trial to show that your defense is irreparably harmed, correct? You can show prior to any trial what the harm would be, correct?
Well, sure, Your Honor. If you could show a speedy trial violation, that would be somewhat
you have to show damage to your defense in order to win there as well. So it's not an uncommon standard.
I think this case is a little bit different than a speedy trial violation, though.
It's a lot different than a speedy trial violation, but what I'm talking about is the ability to show harm to your defense. You don't have to go through a trial to be able to then show harm to your defense, correct?
In that context, sure, because the delay would be the reasons why you would be prejudiced. But here we don't. There isn't anything similar for him to show, like, I am irreparably prejudiced by being prosecuted as an adult based on the law as it was written at the time of the offense.
Under the juvenile code, what is the purpose of the parental involvement in the case?
What's the purpose of the
parental involvement? What's the extent of the right for the juvenile to have the parent involved in his or her case in the juvenile proceeding?
I mean, he's tried as an adult, so under the law, I think as it stands now or below, I don't think he has a right to have a parent present during any time unless he invokes his rights under a separate different statute, which would be related to like an interrogation. Okay,
the defendant in their brief mentions in talking about harm that he wasn't allowed to have parental involvement. And I think the state says, well, the mom did actually get to talk about that here. So what's really the purpose underlying that parental involvement? That's not something that benefits his defense.
Well, Your Honor, the only parental involvement would be if he invoked his right to have his parents present during an interrogation, and that's just simply not applicable to this case. I'm not sure what other statute would say that he has some right to parental involvement in his case, other than if he invoked his right to have a parent present during an interrogation. If that is the statute you're referencing, Your Honor, I'm not certain there is any other.
I'll circle back to it.
So the first constitutional violation that the trial court found was a violation of his Eighth Amendment rights. The Eighth Amendment protects those who have been convicted of a crime from cruel and unusual punishment. The United States Supreme Court has stated that Eighth Amendment scrutiny does not apply until after a criminal prosecution. And this makes sense because if there is no conviction, there can be no punishment that is violative of the Eighth Amendment. And here, as we just talked about, there has been no conviction, there has been no trial, there's been no punishment imposed. So there simply cannot be an Eighth Amendment violation. The defendant points to the decision in Ingram versus Wright to state that it makes clear that the Eighth Amendment also puts substantive limits on what can be made criminal. What that case actually says is there's a substantive limit on what can be made criminal and punished as such. So all three limitations of the Eighth Amendment involve not only a conviction, but punishment after a conviction. The only case that was cited for that particular limitation of the Eighth Amendment was Robinson versus California, where the Supreme Court said that it could not, the statute was unconstitutional for merely making a status of a drug addict punishable by 90 days in prison. And they said that was unconstitutional because the statute did not require the drug user to have, use or possess drugs. It was merely a status, and concluded with punishing someone for even 1 day for the common cold would be unconstitutional. But even in that case, the Eighth Amendment didn't apply until after the defendant was found guilty of that offense by a jury. There's simply no case that I have found or that has been cited to this court where there's been an Eighth Amendment violation that's been found prior to trial. The defendant made an assertion in his brief that Miller versus Alabama somehow criticized or disapproved of automatic transfer statutes. And that language was taken out of context. What the court was discussing is whether giving some discretion to the trial judge to transfer a juvenile over would have cured any constitutional violation in imposing mandatory life without parole. And the court was simply noting that 29 states out of 50 have automatic transfer statutes. It wasn't asked to and did not approve or disapprove of automatic transfer statutes. The Roper-Graham-Miller trilogy also discusses only sentencing practices for juveniles, which we don't have here because the defendant was never convicted of a crime or sentenced for a crime. So, yes, Your Honor.
Can you talk a little bit about your argument concerning the substantive versus the procedural due process? What was argued below? What's argued on appeal? What's been abandoned?
Yes, Your Honor. So the Constitution protects both procedural and substantive due process. The defendant below argued specifically, and I can quote you from page transcript 44 to 45, the due process violation here stems from HALO being prosecuted in an adult court without the procedural guarantees afforded by a juvenile transfer hearing, and then cited Kent versus the United States for that proposition. That is what the trial court found in its order, that due process has been violated under the procedural guarantees of Kent versus the United States. Now on appeal, the defendant says, no, it's not a procedural due process claim, it's a substantive due process claim. Well, in order to assert a substantive due process claim, you have to claim that there is some fundamental right that is being violated that is deeply rooted in this history, in our history and our legal tradition. There was no mention of that below, and the trial court certainly didn't find that this was some fundamental right deeply rooted in our history or legal tradition. If it had, it would have had to apply a strict scrutiny test, and it didn't. It applied a rational basis test. So what has happened here is the defendant asserted a procedural due process claim below, got the trial court to adopt his argument, and then abandon it on appeal and switched horses to say, no, it's not really a procedural due process claim, it's a substantive due process claim, which is also not properly before you because it wasn't argued below and it wasn't ruled upon. Yes, Your Honor.
Can you abandon an argument as an appellee?
I certainly think you can when you specifically say this is not a procedural due process claim. I mean, he's expressly disavowed that claim. But nevertheless, under either of those theories, his claims fail. He was not entitled to a transfer hearing because he was automatically prosecuted as an adult. And so Kent versus the United States simply does not apply to his case. And courts around this country have uniformly held that when a juvenile offender is automatically transferred to Superior Court, the procedural protections of Kent simply don't apply. And that is the case here. Under substantive due process, he has to show that it was some fundamental right rooted in our history. Well, if you look at our history, 16-year-olds have been excluded from the juvenile justice system for the last 100 years. And so this brand new legislation, which would allow some 16-year-olds and 17-year-olds to remain in the juvenile justice system, the novelty of that legislation cuts against his substantive due process claims. There is no fundamental or inherent right to be treated as a juvenile.
How long does it take for something to become fundamental? How long does something have to be in history, a change in our nationwide system for it then to be fundamental?
I don't know that there's a specific number of years, but what the United States Supreme Court has said is that a fundamental right either has to be explicitly or implicitly included in the federal constitution or our state constitutions. And so I would assume going back to the time where those constitutions were made, it would have to be fundamentally included and deeply rooted in our history, such as the right to marriage and the right to procreate, things of those nature. And the Supreme Court has warned against finding new fundamental rights. And so there's not a single case, either state or federal, that has found that the juvenile justice or juveniles have a fundamental right to the juvenile justice system. It's purely a matter of legislative prerogative. And I've cited.
Your time's getting close, so I just want to warn you if you want to save the rest of it for rebuttal.
Yes, Your Honors. Yeah, I'll wrap up fairly quickly. So it's a matter of legislative prerogative, and that's the way that it's always been. That's the way that it's still been. And there are a number of juveniles still to this day, even under raise the age, that will be excluded from the juvenile justice system based on whether this is their first offense or the crime that they were alleged to have committed. Your Honors, I would like to save the remaining time for rebuttal if that's okay with you.
Yes, that's fine. Thank you. All right, Mr. Andrews.
May it please the court, my name is David Andrews and I represent Halo Garrett. I urge this court to affirm the order below because the trial judge correctly protected Halo's constitutional rights. There's been discussion about due process, so why don't we start there? We do have this threshold question of whether the defense attorney raised substantive due process below. The answer to that question is yes. First and foremost, she used language for substantive due process in her motion and at the hearing on her motion. She expressly talked about fundamental conceptions of justice. That language, it's just a slightly shorter version of the test under Snyder. Whether a procedure involves principles of justice that are so rooted in the traditions and conscience of our people as to be ranked as fundamental, it's just a somewhat different formulation. In the introduction to her motion, she talks about how North Carolina and New York were the last two states to raise the age. She talks about how there were 5 states back in 2017 that set the age for juvenile court jurisdiction at 17, and the remainder set the age at 18. The hearing itself was pitched in much the same way. She talked about North Carolina finally joining this national consensus on including 16-year-olds in juvenile court. She started the hearing with a quote, a Martin Luther King quote, "The arc of the moral universe bends towards justice." What she's getting at is North Carolina has finally reformed juvenile court and extended it like every other state.
Okay, so Mr. Andrews, let me ask, if that's the case, the question that Judge Collins asked earlier, what is supposed to happen with someone in this sort of gap, you might say, between the two? If this were to be upheld, someone between the age of 16 and 18, if they can't be prosecuted in Superior Court, these are, of course, obviously things happening before the raise the age legislation. Then what happens with them? What do we do with them?
What I can say is for Halo Garrett, the prosecutor and the defense attorney agreed that there was no procedure for the state to take him to juvenile court. Courts can't create those procedures, okay? And the only honest answer, I think, it's not pretty, I don't necessarily like it, but the only honest answer is dismissal of the charges, okay? And I think everyone below agreed to that. What I do want to say, though, is that even though it would leave Halo Garrett off the hook, so to speak, it's imperfect. There's not really another alternative here, but Ramos, for example, from last term in the U.S. Supreme Court, kind of speaks to this. That was about jury convictions that lacked unanimous jury verdicts. And the Supreme Court said the magnitude of a legal wrong is no reason to perpetuate it. What we're dealing with here is this threshold question. Does it violate the Constitution to automatically prosecute a 16-year-old charged with a low-level offense in adult court? That's the threshold question. We need to get over that hump first, and then we can think about the remedy.
Well, now you refer to it as a low-level offense. I think the charge was breaking and entering larceny. Is that right?
It's a low-level felony, like I think a class H.
Felony. Okay.
Right. You're right. I misspoke. I apologize.
Okay. All right. So was this an as-applied or facial challenge? And what is the order? Is it as-applied or facial?
It's, you don't see the terms as applied or facial in the motion. I think there are elements of both, because she's talking, the trial attorney is talking about what all the other states do for 16-year-olds and Halo being deprived of that. It's as applied in the sense that the defense attorney presented evidence that was specific to Halo, specific to the client, about his circumstances and his needs at the time of the offense date, that he was immature, that his mom had tried to get him services but was unable to. And so in that sense, being deprived of juvenile court had a specific effect as applied to him, but it is a little bit of both here.
So are you saying that should we treat this as facially unconstitutional or as applied?
I think you can do it as applied to Halo Garrett, but I do understand that you'd be creating precedent on an as applied challenge. All right, so
we're set, Mr. Andrews. If such a precedent were set, and we recognize that he does have this right, doesn't that cut against the idea of the state legislatures being laboratories of democracies? The whole point of a laboratory is to see what works and what doesn't. If we were to say that this is now a fundamental right, then that means the legislature can't come back 10 years from now and say, no, we don't think so. This didn't work out very well. We're going to start sending 16 and 17-year-olds back to regular superior court for their felonies automatically. We're going to get rid of this change to our juvenile system. Doesn't that completely undercut the whole purpose of a laboratory of democracy?
Well, okay, laboratories of democracy is a helpful way of looking at this. But I think what's relevant to that point, though, is contemporary practice under substantive due process. And what's remarkable here is that we aren't talking about a plurality of jurisdictions. We're not talking about a majority of jurisdictions. We're not talking about a vast majority of jurisdictions. We're talking about something really extraordinary, complete unanimity, which is to say every state and territory not only has juvenile court, but over time, over years, you could say 100 years, they have all reached the conclusion about the wisdom of juvenile court and that it should include 16-year-olds. Okay, and the reason that that's...
Talk about that. So over 100 years, all courts have agreed that it saves everybody money. That doesn't cure a constitutional violation. All courts have agreed that this works better for the justice system. We're talking about implementing this raise the age not to cure a constitutional violation, but for other policy reasons?
You know, there were a lot of policy reasons, several, to raise the age for juveniles to 18 in North Carolina. They're listed in that report. But I really do think that a helpful way to think about raise the age legislation is that it brought North Carolina into constitutional compliance because of this consensus, this unanimous consensus around the country. At that point, it was 48 against 2. New York and North Carolina were the last two holdouts. And so that's why I think of raise the age as, we can really thank our former Chief Justice for pulling North Carolina into constitutional compliance, because in 2015, there were only 2 states that didn't grant access to 16-year-olds. When you look at a case like Cooper v. Oklahoma that goes through contemporary practice, they're looking at a different question. They're looking at the burden of proof at capacity hearings. But they state, only 4 jurisdictions used a higher standard of proof. And because all the other states used a lower standard of proof, that was enough of a consensus to say that that higher standard of proof was out of compliance with the Constitution, with due process. Okay. I do want to talk about.
Mr. Andrews,
Yes.
I'm sorry, let me ask you one other thing. So
Please.
if we were to uphold the trial court's order and say this was unconstitutional, what effect would it have upon, how far would it have a retroactive effect? So for others who were prosecuted in that age gap, either during this time or even 5-10 years ago, whatever, could they come back and challenge that and say that those were unconstitutional?
Okay, I think some would, only by virtue of the fact that this case, by 2015, we had enough of a consensus, 48 against 2. The threshold question here, though, is whether there even is a constitutional violation here. I think if you just hypothetically were to rule for Halo Garrett, just hypothetically, I think the follow-up question that would need to be litigated is how far back does it go? When did this consensus emerge? And that's going to take additional litigation. It will take motions for appropriate relief filed by former juveniles who were convicted in adult court. They would have to file a motion for appropriate relief, litigate this question about when this consensus emerged, get a ruling from the trial judge, and then whoever loses appeals. And it comes back to this court for a pure retroactivity analysis. We're not in that procedural posture here because this is a direct appeal, right? We're not dealing with a motion for appropriate relief. Okay.
Mr. Andrews, real quick before we move on from that, with our cases for a number of decades now or the U.S. Supreme Court cases have talked about the evolving standards of decency, and looking at those to include what's happening internationally. I don't see anything in the record here dealing with anything internationally as to juveniles, and the trial court didn't make any findings on that. So do we have an incomplete analysis for cruel and unusual punishment purposes?
I don't know if it's incomplete, and don't let me stop you from looking up international law. But what I will say is that at least domestically, it is truly remarkable that we've had this consensus building among all the states in the Union and the territories, and each one of the laboratories of democracy has chosen to include individuals like Halo in juvenile court. They give them a pathway. I think you could just look at this country, and that would be enough to look at evolving standards of decency. That was enough in Atkins, I believe. Sure, it'd be helpful to know more about international laws, but I think we have enough here, if that answers your question.
It does. I want to go back to the question I asked Ms. Callahan, and I found where I was looking at it. It was in the record, not in your brief. But looking at record page 22, paragraph 10, this is the trial court's order, finding of fact 10. The 4th line going into the 5th, in saying what he misses out on by not getting juvenile proceedings. There's no requirement of parental notice or involvement. What is the trial court speaking of there, and what difference does that make in terms of his ability to prepare his defense of his case?
I don't know if that is necessarily about preparing a defense for the case. Just, in the moment right now, looking at that, what that speaks to me is the philosophies between juvenile court and adult court. Juvenile court, parents have to be involved. And, one of the main reasons is because they're the primary caregivers for kids. Another sort of bird's eye view of juvenile court is that they offer rehabilitative services to kids. Okay. We're talking about family therapy, for example. We're talking about supervision. And if you think about it in a broader sense, juvenile court is trying to help, in some measure, provide more stability for kids who don't have stability in their lives. I suspect that parental notice requirement is part of the philosophy. It's referring to part of the philosophy of juvenile court in helping give a child who's gotten into trouble more stability. I hope that answers your question.
Yes, I appreciate that. And let me ask one more question regarding kind of preservation in the due process. Since
Okay.
The trial court did not find substantive due process. You're saying to file any type of cross appeal. Is that even the substantive due process even for our consideration?
The trial judge found a violation of due process. I don't think the judge specified procedural or substantive. The judge just said it violated due process, And then when you're looking at a case like State v. Austin, which I've cited in my brief, I don't remember the page. State v. Austin, it talks about the question for review is not the specific reason given for the judgment. It's whether the judgment is correct. Okay. At the end of the day, though, I really do think the whole argument here, when you step back, let's not miss the forest for the trees. The defense attorney was saying, hey, everyone, North Carolina did something huge. They joined every other state in giving someone like Halo access to juvenile court. That concern is a concern that is addressed by substantive due process. When you look at a question of access to the courts, you can look at Bounds v. Smith. I've cited that in my brief. Access to the courts is a fundamental right. When you're talking about fundamental rights, you're talking about substantive due process. That's what the trial attorney was getting at. Was it perfect? Was it eloquent? It was eloquent, but maybe it wasn't perfect. For issue preservation, perfection is not required. And that's why I've included in the memorandum of additional authority State v. Spence, State v. Murphy. There are two cases I encourage you to look at. And they talk about how even in those cases, you could look at Murphy, where our Supreme Court held that the defendant preserved an argument that was, quote unquote, not specifically argued, nor clearly and directly presented because it was implicit in the defendant's argument. If nothing else, that's what's going on here. The defense attorney was talking about North Carolina joining a national consensus. When you're talking about consensus, that's substantive due process. Did you have a question, Judge Murphy?
I do. It kind of mixes in with what we've been talking about a little bit, but with the national consensus, and I can't remember if it's in the orders or in part of the presentation, the brief or below, discusses what's happened with certain Native American tribes. Would we consider that in our domestic considerations or in terms of a separate sovereign international consideration?
I will let you decide. I don't know off the top of my head. I'll just be honest about that. It's yet another example of just walking around knowledge of how we treat kids. I mean, it's sort of this broader idea. How old do you have to be to join the military? 18. How old do you have to be to vote? 18. How old do you have to be to sign contracts? 18. It's almost a cultural thing in addition to being a question of contemporary consensus for substantive due process matters, okay? I do want to mention State v. Burnett. That's this 1919 decision that upheld the constitutionality of juvenile court. The reason I mention that is because it puts juvenile court in historic context, which I think is important for this court. It hasn't really come out yet. It states that juvenile court was really just an extension of the infancy doctrine. Okay, this is the doctrine that everyone learns in law school, where children under 7 are presumed to be incapable of committing a crime. When you're 7 to 14, there's a rebuttable presumption that you are incapable of committing a crime. And the Supreme Court says that creating juvenile court, quote unquote, only operates to extend the conclusive presumption in all cases to children under 14. I raise that because I just want to put juvenile court in context. Yes, it's been around for 100 years in this state, but really, truly, when you think about it, it is a reflection of this ancient doctrine. It's an extension of the infancy doctrine. What does the infancy doctrine do? It shields children from criminal liability. What does juvenile court do? It shields children from criminal liability. Juvenile court is reflective of this old pre-American law, even pre-English common law tradition. And then, as I mentioned before, on the contemporary practice front for substantive due process, we're talking about complete unanimity. The reason that unanimity on the age of juvenile court jurisdiction is so important is, as I mentioned, it goes directly to the test under Snyder. These are 50-plus separate legislative, democratically elected representative bodies who are coming to independent conclusions about the wisdom of juvenile court and what it should extend to. All of these legislative decisions, they're showing the values of our country in each and every state. All those values, all those legislative acts show that juvenile court and extending it to 16 is now firmly rooted in our country, that including individuals like Halo is worthy of being included in the pantheon of fundamental rights. Now, it may be that courts don't often hold something to be a fundamental right, but juvenile court passes that test, including 16-year-olds in juvenile court also.
I'm going to jump in. So if all 50 states have now raised the age, have any of the remaining 49 states dealt with the issue before us today? What happens to that, basically, that group of individuals in the same group as Halo is?
For lack of a better term, it might be donut hole kids. And even Halo Garrett predates that group. I don't know of a case off the top of my head, okay? The best that I can give you, and this is imperfect, is State v. Santiago, which I included in the equal protection argument at the end, toward the end of the brief. And that was a case about the death penalty, where the state of Connecticut got rid of the death penalty, but only made it prospective, okay? And the Supreme Court of Connecticut held that it really should have applied to everyone on death row, and that those death row sentences were unconstitutional as well. It's an imperfect analogy, but I just suggest that to you to help you answer this question.
And did we analyze that under the 8th Amendment, I would assume, for cruel and unusual, correct? As I recall.
So
how does the cruel and unusual punishment amendment apply here when, as the state argues, there's no punishment?
Okay, let's think about the 8th Amendment as a general matter. Yes, it proscribes cruel and unusual punishment, but it's broader than that. It prescribes excessive bail, right? So just the 8th Amendment itself, it goes beyond convictions and punishment and has a protection for bail, which arises pre-conviction, even pre-trial, okay? But then when you're looking at the cruel and unusual punishment clause, Ingram v. Wright is informative here. I know the state has talked about that, where the Supreme Court says that the cruel and unusual punishment clause, quote unquote, circumscribes the criminal process, okay? And that's not a stray remark. The Supreme Court went on to say that the cruel and unusual punishment clause, quote unquote, imposes substantive limits on what can be made criminal and punished, okay? That is the limitation we're talking about here, and I do want to stress, I encourage you all to look at Robinson v. California, okay? In that case, the Supreme Court held that a law that, quote unquote, made a criminal offense of a disease would violate the prohibition on cruel and unusual punishment. What's notable about Robinson is that the Supreme Court looked at the sentence in that case, the 90 days I believe the defendant got, and held that that particular sentence doesn't violate cruel and unusual punishment. The focus of the prescription in Robinson v. California, what did violate the cruel and unusual punishment clause, was the legislative act of making being an addict a crime, okay? The focus was the conduct that the legislature made criminal. The Supreme Court imagined criminalizing other types of diseases and said even 1 day in prison would be a cruel and unusual punishment for the crime of having a common cold. There's a similar dynamic going on here. It's not a specific crime that we're talking about, but it's still a specific group whose conduct the legislature has made a crime and has made punishable. Under the law in the offense state, as you all know, the General Assembly made it an offense punishable in adult court for 16-year-olds to violate criminal laws. But when you survey jurisdictions around the country, as you do with Eighth Amendment claims, not one state, not one territory automatically prosecutes 16-year-olds for violating criminal laws. Under Robinson, that third limitation of the cruel and unusual punishment clause should come into play here. If you apply evolving standards of decency, it's a violation of the Eighth Amendment to automatically prosecute a 16-year-old like Halo directly in adult court.
Chambers,
Yes.
I wanted to ask, we know, of course, obviously all the states have changed their legislation on this, but did any state ever hold it to be unconstitutional to prosecute, say, a 16-year-old as an adult before the legislature in that state changed the law? In other words, did any legislature ever change it in response to a holding of unconstitutionality, or was it that they decided for various policy reasons to change the law?
I don't know of a case off the top of my head. If I had to guess, I'd say that the legislature's changed the law. I don't know. It is a bit of a mystery. Maybe no one brought a claim in court, for all I know. I do want to get to this point about Roper, Graham, and Miller, and the state has argued that they don't apply here. I think they do apply because there's a direct link between the concerns in Roper, Graham, and Miller, especially involving adolescent brain science, and the age of juvenile court jurisdiction. Those decisions, they formed part of the basis for Raise the Age law. They're discussed on pages 16 and 17 of the report that I included in the appendix, the report of the Commission on the Administration of Law and Justice. And their inclusion as part of the rationale for raising the age, it makes sense. If a kid is less culpable for sentencing because of mitigating factors of youth, then they're less culpable for inclusion in adult court to begin with. Graham is also especially relevant here because it has that quote, criminal procedure laws that fail to take youth into account would be flawed. That echoes a case that the state included in their reply brief, Breed v. Jones, which talks about how transfer itself gives judges the quote unquote flexibility needed to deal with youthful offenders. Okay, the key word here is discretion. What's lacking here is any discretion for a judge to determine where Halo should have gone, adult court or criminal court. Kent speaks to this, and I know Kent has been viewed as a procedural due process case, but it's not monolithic. Kent is not monolithic. It speaks to the importance of this discretion because what the Supreme Court says in Kent is that transfer is so important. It has tremendous consequences. Transfer, the procedure that Halo wanted access to, the way to look at it is it has the ability to alter life trajectory. That's how serious transfer is and why Halo wanted access to that. He just wanted his chance to argue to a judge, I need to stay in juvenile court. For a kid who goes to juvenile court, they get that family therapy. They have a chance to rehabilitate themselves and they don't come out with a criminal record. For the kid who goes to adult court, They get the arrest record if they're arrested. If they're convicted, they get that permanent mark on their record.
But Mr. Andrews, I think as you acknowledged at the beginning, he literally could not have gone to juvenile court, right? Jurisdictionally under the statutes existing.
That's true. But what I'm saying is it violates his constitutional rights because he should have had access to transfer. Right. You know, the provisions of raise the age should have applied to him. Are there any other questions? I see my time is winding down.
Well, just you're talking about the policy reasons and the brain science and all that, which I'm very familiar with.
Right.
So why age 18? There's a lot of that shows that actually, you know, the brain development doesn't complete until the early 20s. So could we have a 19-year-old, a 20-year-old coming and saying, hey, you know, my level of mental maturity is, you know, I'm not there under all this brain science, and therefore it's unconstitutional to treat me as an adult. Why not?
That day may yet come. Vermont sets the age, I believe, at 22, for example. Mm-hmm. There's been an Eighth Amendment case in Kentucky in trial court called Breadhold that I believe refused to apply the death penalty to a 21-year-old for that very reason, Your Honor. That argument may yet come, but I will say, as to substantive due process, when you're looking at consensus, we don't yet have consensus on that matter. Maybe we'll have something under the Eighth Amendment, under this theory of adolescent brain science. You have a case like Moore v. Texas in the U.S. Supreme Court, which has to do with intellectual disability. And the Supreme Court said, look, judges don't need to be deciding this question of intellectual disability. Follow the science. Let the scientists decide who is intellectually disabled and what the criteria could be. You could make that same argument for adolescent brain science, that we should follow the science and not arbitrary decisions made by judges and non-scientists. I see that my time. Go ahead, Judge Murphy.
Real quick, in your memo of additional authority, you included NCGS 15A 1340.12 and also McGirt versus Oklahoma. Is there anything in particular you want us looking at regarding those two parts of your memo of additional authority?
Gosh, I sure appreciate that. The criminal statute I just pointed out because the primary purpose of sentencing is to punish, which is different from juvenile court, which is to rehabilitate. I wanted you all to look at McGirt because it addresses the floodgates problem that we've been talking about, all these kids coming out of the woodworks to file claims. McGirt directly addresses the floodgates problem. It talks about a huge jurisdictional problem in Oklahoma. The Supreme Court ruled for the defendant in that case, and they say, dire warnings are not a license for us to disregard the law. The magnitude of a legal wrong is no reason to perpetuate it. There might be a huge problem, but you've got to follow constitutional protections. I see that my time is up. I would just ask you all to give HALO what every other 16-year-old in this country gets. I ask you to affirm the order below. Thank you very much.
Ms. Callahan?
Yes, Your Honor. I would like to take this time to address 2 points. First, the defendant's assertion that the trial court ruled on substantive due process. I would point this court to finding of facts 24 and finding of facts 26, and where the trial court is stating what the juvenile actually argued below. And his argument was that he did not get a transfer hearing and findings in favor of transfer based on Kent versus the United States. And that is what his due process violation was found by the trial court. There is no indication in below or in this order that there's a substantive due process violation found. Defendant had the burden below in the trial court to show constitutional violations, and they should not be considered for the first time on appeal. I'd also like to take a minute to discuss the implications of this court holding that there is some substantive due process violation in this case. If this court were to hold that there's a fundamental right to access to juvenile justice system for a 16-year-old, I know that defendant has tried to cabinet to this particular case, but the implications of that holding would be far-reaching. I'm not sure how that wouldn't apply to every single juvenile who was prosecuted in between the time that the law was passed and its effective date. If there is a fundamental right to juvenile justice system that's historically rooted in our legal tradition, which it's not, but if this court found that, I'm not sure how it wouldn't apply to every single 16-year-old that has ever been convicted of a felony in this state. And I'm not sure if the statute says they are now even under raise the age would hold up under that type of ruling, because as we've discussed earlier, there are a number of juveniles, even under raise the age, that are still excluded from the juvenile justice system if this is not their first offense, or if they commit a Class A through a Class G felony. Or how that would even apply to younger juveniles who commit murder, because they are automatically transferred to Superior Court too. So if this court holds that there's some fundamental right to access to the juvenile justice system, I'm not sure how that doesn't apply to all of these people. This court would be the very first court to hold that, in contravention to a plethora of authority which holds to the contrary. Even the United States Supreme Court in Ray Goltz found that there was no common law right to be treated as a juvenile. It is purely a matter of legislative prerogative. And the defendant is asking this court to completely ignore the legislature's directive that this legislation is prospective only. He wants it to retroactively apply, not just to him, but this will be used many times over to allege that juveniles' fundamental rights have been violated. That right simply does not exist. It's a matter of legislative prerogative, and the General Assembly has decided to exclude a defendant from the juvenile justice system, and a trial against him should have proceeded. I would ask this court to reverse the trial court's order.
Thank you very much. And thank you all both for your excellent arguments. And I'm glad that our WebEx adventure in court here is still going pretty well. Thank you all very much.
Thank you.
We will adjourn.
This session of the North Carolina Court of Appeals is now adjourned.